Council, we are just going to wait 5 minutes for the third applicant's council to join the platform.
That's fine.
Apologies for the delay.
Thank you.
Boity? Those guys. Can I confirm that council for the third applicant, All Truck Drivers Forum and Allied South Africa, is on the platform and ready to proceed? Council for the third applicant, All Truck Drivers Forum and Allied South Africa.
Sorry, let me just give you an update because I came to know who are the counsel in the matter. I spoke to Mujapilu.
Yes, council.
He says he thought it was 10 o'clock, but he's trying to connect now.
Okay, thank you for the update, council.
Yes, thank you.
May it please the court.
Thank you. Can we start?
Thank you. This is in the High Court of South Africa, Gauteng Division, Pretoria. Today is the 18th of September 2023. This is an application for leave to appeal before the Honorable Madam Justice Collis J, before the Honorable Justice Malindi J, before the Honorable Justice Mota J. This is case number 32323 of 2022. In the matter between the Minister of Home Affairs, the first applicant, the Director General of the Department of Home Affairs, second applicant, All Truck Drivers Forum and Allied South Africa, the third applicant, and Helen Suzman Foundation, the first respondent, and Consortium for Refugees and Migrants in South Africa, the second respondent. May it please the court.
Yes, thank you. Just confirm your names for the record.
As the court pleases, my lady, and the two justices. My name is William Mokari. I appear with my colleagues who are sitting with me here, Mr. George Addis and Mr. Mokatla, for the applicants, which is the Minister and the DG.
Thank you, Mr. Mokari. The third applicant.
My lady and justices, firstly, I would like to apologize for the late connection. We had a problem with the information of what time, and then the second issue was the technical issues, but we were initially told that it was 10 o'clock, so apologies. My name is Mujapelo MM. I appear with my learned colleague, Mtsweni. We are together in the same room.
All right, thank you, Mr. Mojapelo. Then the first and second, well, first respondent.
Good morning, Malay Canberg, and I appear with Mr. McConaughey, Mr. Gekwa, and Ms. Kritzinger for the first respondent.
Thank you, Ms. Steinberg. The second respondent.
May it please the court, I appear on behalf of the second respondent, Kormsa, in this matter.
Thank you, Mr. Simmons. All right, you would be aware that I'd sent out a communication last week around the time allocation for the hearing of this leave to appeal. We've now already 15 minutes behind, so all of you are requested then to try and make up the time. And the reason for that is simply that we have other responsibilities to attend to after lunchtime. So can I ask you to try and make up the time that we've lost now as far as possible? All right. You can accept that we've read your heads of arguments, and thank you for preparing those heads. So if you wish, you can just simply succinctly take us through the salient points that you want the court to focus on in your respective applications, and also the opposition to those applications. All right. If you are not addressing the court on the platform, you're welcome to switch off your microphone. Obviously, your microphones must be off, but also your video feed, and only switch it on once you are addressing the court. The three justices, obviously, we will keep our microphone and our video feeds on. Thank you, Mr. Mokari.
Thank you, my lady. My lady, I am going to speak softly. I hope that my sound system is very good, and even if I speak softly, you'll still be able to hear me, because I'm missing my voice because of flu. But I'll keep on drinking warm water as I go along.
With some lemon, I hear it's very good. So, warm water with some lemon.
Thank you, my lady.
Thank you, Mr. Mokari. We can hear you clearly. You may proceed.
Thank you very much. My lady, as you have already pointed out, this is the leave to appeal, which has been filed against the judgment and the order that this court has delivered in this matter. I'm alive to the time allocation that the court has given to each of us. I promise that I will stick to the time frames as given to us by the court. I'm also going to simply highlight the salient points which are relevant to the leave to appeal in respect of the 3 grounds of review which the court upheld in favor of the Helen Suzman Foundation or in favor of the respondent, in order to demonstrate that on the test postulated in section 17(1) of Superior Courts Act, another court would come to a different conclusion because of the requirement that where there are prospect of success on appeal, the court should grant relief so that the appeal court can consider the matter. The orders that the court made appear at page 62, that is 00062. It is 2 types of orders. One is the main order of review and setting aside, which was granted in terms of the powers that the court has, depending on whether the court grants it under the Constitution, which is section 172(1), then it will be an order under that section to declare a conduct which is invalid and unlawful to be so, and to review and set it aside. And it will also depend whether the court is doing so under PAJA, and on that occasion, the court will also use a different legislative regime in respect of the appropriate remedy. If it does so under PAJA, it will be under section 8, and if it is the review under legality, that is section 1C of the Constitution, it will be under section 172 of the Constitution. So we are appealing against the order in paragraph 147 as a whole, including the consequential orders which were made by the court in paragraph 147.4. In this paragraph, the court exercising its powers, as it said, under section 8 of PAJA, it says it granted an interim relief, and it also did so, as it says, under section 172(1)(b). But I'll come to why we say that the court could not competently do that under these 2 separate regimes when I address the appropriate remedy. But first, I'd like to point out those aspects of the judgment right at the beginning, which we agree with. Paragraph 1 of the judgment at page 0002, the court says that this application concerns matters both of great importance and of striking ordinariness. My emphasis is on the great importance. We agree with the court that it is a matter of great importance, and this is also emphasized by the court in paragraph 2, the last part of it, 0003. This is thus a case of considerable public significance, not only to all ZEP holders, but to the Department of Home Affairs as well. We agree with this because this is not only a matter of great importance and of considerable public significance, but is a matter that raises huge constitutional implications, which revolve around issues of asylum, immigration, the refugee, economic, political, and socio-economic considerations which any country has to take into account when dealing with how it deals with the acceptance of foreigners in its own or within its own borders. So it is a matter, of course, of huge public importance. The history has been narrated by the court as to where this Zimbabwean dispensation originated. What we wish to also highlight, which the court was also alive to, is paragraph 3 and 4. In 3, the court said, while the minister has recently extended the grace period by a further 6 months until 30 June 2023, his decision to end the ZEP program remains unchanged. In paragraph 4, the court says, in terms of the said program, and for approximately the past 14 years, qualifying Zimbabwean nationals have been granted permission by the Minister of Home Affairs to live, work, and study in South Africa. And in paragraph 5, it says, as a consequence of being granted this permit, ZEP holders have established lives, families, and careers in South Africa. The termination of this program has placed all this in jeopardy, which decision holds profound consequences for ZEP holders. This much is common cause between the parties. So the court was alive to the fact that the Zimbabwean dispensation had its origin on the policy that was adopted by government through, of course, the executive responsible for Home Affairs, which is the minister, as way back as 2009, as a policy decision of government that due to the influx of Zimbabweans into South Africa, as a result of instability in their country arising from socio-political and economic circumstances, and the strain that influx was causing on the immigration regime of South Africa, the inability to cope with asylum seeker programs in place. Government took a decision that as a matter of its policy, it will grant the Zimbabweans some form of a dispensation which will regularize their illegal stay in South Africa in order to avoid putting strain on people coming in and deported back and coming back, deported back, putting strain on government coffers. So that was the government policy at the time in 2009. And that has been flagged actually by the court in the sequence from page 00010, paragraph 21 onwards, where it deals with the history of the ZEP. We know that it was changed in terms of how it was called in different times. Initially, it was called the DZP, and of course, then we know what that entailed. It was called Dispensation of a Zimbabwean Project, and later in 2014, it was then called something different and replaced with Zimbabwean special permits. And in 2017, it was again called the ZEP, which is Zimbabwean Exemption Program. But all the three of them remained with one focal point, which was to temporarily ensure that Zimbabweans remain in South Africa until such time that government, and here when I say government, I use it in the context of the responsible executive for Home Affairs, because he's the one who is empowered as the executive to take such decision or policy decision. So when I say government, I'm referring in that context until government is satisfied that it can terminate this program. So we are aware that there has been a debate when the matter was argued initially as to whether there was a termination of this dispensation by the minister or whether it was something different. But after the court has analyzed the facts, especially at objective level, it concluded that indeed there was a termination of this dispensation. And I'd like to place on record that we do not take issue with that conclusion, that indeed there was a termination of this dispensation by the minister. And what the minister continued to do was to provide grace periods in terms of periodic short extensions for those permits, as it has been enunciated in the judgment. But the decision, of course, was taken that the program is terminated, and what was left was how to ensure an orderly implementation of that decision, taking into account the material conditions on the ground, that if it was feasible at a particular time, it could be implemented right away. If not, the minister from time to time takes a decision to provide those grace periods to extend then those permits. So the issue really then before court, as the court correctly pointed out, was whether the termination of the Zimbabwean dispensation of the exemption program that was given to the Zimbabwean national accorded with the constitutional prescripts, and whether it was done in a manner that is permitted by law. And permitted by law here, it will be law of general application in respect of the acceptance of foreigners in the country, them being granted exemption, and at what point that exemption may be taken away. So this one, it was a special dispensation which was initiated temporarily to deal with a particular situation which was prevalent in 2009 and continued so until when the minister decided that those conditions were no longer prevalent, and therefore there is no more legitimate or governmental legitimate purpose to allow this dispensation to continue. Hence, it was terminated. So that would have brought the court to the determination of whether that termination falls under Administrative Act or whether it is an executive decision or one that is more closely linked to policy making or whether it is policy laden. So we submit that on a proper scrutiny of this decision, looking at how initially it was taken in 2009 and the purpose it sought to serve and its termination, it is one that is more akin to a policy laden decision than administrative decision. And that becomes material because the factors that the court looks at in order to determine whether an act performed as administrative or executive is not an easy one. In certain areas, it's quite a gray area, and that is why the Constitutional Court attempted to assist the courts, and I would say lower courts like high courts, when they are confronted with such matters, whether to determine the nature of the decision or act, to look at the factors that the Constitutional Court has set out in Mutau versus Minister of Defense, and paragraph 36, 37 to 40 of the judgment are quite instructive on what the court must look at. So we say that when one looks at the features, that this was a policy-laden decision, and therefore the only way the court, the only way the minister's decision could be attacked is whether the minister's decision is rational. Rationality is a low threshold type of review because it is more linked to the principle of deference, where the courts are loath to interfere with executive decision making, particularly when it is more linked to policy. Because where policy comes into picture, there are many complex issues which are interlinked with other features such as economy, security, then politics, and so on. So the courts are often reluctant to enter into that terrain because it does not regard itself as a specialized forum to make such determination. So we submit that what the court ought to focus on will have been to determine whether the decision to terminate was a rational decision or not. And in order to determine whether a decision is rational, the court should be guided by what the Constitutional Court has said in the President of the Republic versus the Democratic Alliance versus the President of the Republic of South Africa, what is referred to as a Similani decision, the reasoning by Yakub J, as he then was. So a rationality, one must consider then or a close examination of the origin of the decision and the end of it. So one has to look at what was the purpose of the initial decision in 2009, and one must look at the end of it, whether it achieved what it sought to achieve. If the court finds that the initial decision, which was to give reprieve at a temporary basis for Zimbabweans because of the situation in the country, then the court cannot interfere with the decision to terminate if the executive concludes that those conditions are no longer prevalent, and therefore this dispensation must come to an end. So you find that there is that link between the origin and the end. And if that link then exists, the court should be loath to interfere with that conclusion, even if the court were of the view that it would have dealt with the matter differently. So we rely then on the Similani judgment for that purpose, and we say that the court ought to have exercised or embarked on that exercise of rationality. What the court did here was to embark on a procedural rationality inquiry, but it intertwined it with procedural fairness. And the two are quite distinct because the one, which is procedural rationality, rests in the Constitution, which is 1C. That is the procedure that one embarks upon to arrive at a decision must be linked to the purpose of that decision itself, whereas procedural fairness rests in PAJA, where one simply looks at whether Audi has been granted to the affected person. So the two serve completely different purposes, and the test is completely different, but the court has conflated the two as if procedural rationality is the same as procedural unfairness, whereas then they belong to the two separate regimes of attack of decisions by public officials or organs of state. So then we say that the appeal court could find that it was inappropriate for the court to have dealt with the termination decision as part of Administrative Act when it ought to have dealt with as a policy-laden decision which required deference, and the minister then to be given that space as long as he was able to justify the reason why the decision to terminate was arrived at. So that brings me to flagging the grounds of review under PAJA to the extent that the court has determined that PAJA applies, and we say that PAJA did not find application because of the nature of the decision based on Mutau, but to the extent that the court has found that the decision affected members of the ZEP adversely, and therefore it was incumbent upon the minister to have consulted with them. That again, it goes to whether Section 3 and 4 of PAJA would apply, and if it applies, how it has to be implemented. We are alive of the judgments which require a prior consultation and judgments which permit post-consultation, as long as the circumstances of the case are of such a nature that the decision maker will still remain open-minded and persuaded by the submissions that have been made post a decision. So we submit that in this context, one will find that although the minister did not embark on a prior consultation with the ZEP members, the minister did engage with them and receive representations post the decision so that he can still remain with an open mind in order to still make a decision if persuaded otherwise. But the court has found that the minister has already closed his mind because of the utterances that have been made preceding or even after the opportunity that has been given by the minister to the ZEP members, because the minister said the decision is final, and so the minister has closed up. But we submit that the type of representations that were made and which were received were of such a nature that did not tilt the scale on the state of mind that the minister had already pronounced himself on. But that again goes to procedural fairness. And the other point that the court raised related to the impact on the Zimbabwean exemption permit holders, that the minister did not take into account the impact that that would have because of the duration that members of the ZEP have been in the country. They've been in the country for over 14 years. If one takes from 2009, they've had children and they've had families, jobs, and other forms of relationships that they have established in the country, and that the representations by the DG which he made to the minister did not take those factors into account. So those factors, of course, are factors which will be inherent in any decision making, and the minister dealt with that in his affidavit. When I say the minister, I'm referring to the affidavit deposed by the DG. I'll come to the criticism that was leveled on the absence of the confirmatory affidavit by the minister, but the affidavit was, of course, filed on behalf of the minister, which dealt with those aspects of the impact that the decision will have on the ZEP members, and of course the court has said that it was common cause that such decision, of course, will affect the ZEP members. It will affect even the children, but of course then in situations where the interest of the children come into play, the court then always assume an upper responsibility, including providing the necessary directive as to the necessary information that must be placed before it in order to be satisfied, including the appointment of the services of family advocates to determine the impact that will have, and also ensuring that the interests of the children are objectively taken care of, not on a subjective basis. So the court always assumed that inherent power as a super guardian, upper guardian of the children, to ensure that the interests of the children are catered for. What is always clear is that when the dispensation commenced in 2009, and it continued for a period of 14 years, it was almost inextricable that the Zimbabwean ZEP members will assume a certain obligations and duties within the country, including having employment and also conducting their education and having children. And that is what always has been foreseen, but that could not have created an impression that the dispensation was created to be permanent, but it still remained a temporary measure in circumstances where, when the time comes, then the Zimbabweans will have to return to their country, when one can say that their country is now safe, the democratic processes have returned, and the economy of the country is recovering, and they should be able to return to their country, because their legalization in the country was on a temporary basis and not on a permanent basis. So that is how then the court then will deal with situations pertaining to the children and balancing then those conflicting rights. The court has dealt with the issue of dignity, for example, but dignity, of course, then entails the balancing of rights in the context of whether the dignity that is alleged to be impugned is one that cannot be ameliorated by other measures that government can put in place in ensuring that the return of Zimbabweans is done in a manner that is orderly and a manner that does not fragment families. So that can always be ameliorated with the implementation of the program itself, than to close up and say that as long as it's going to affect their dignity, because then their children are already accustomed to staying in South Africa. The upshot of it is to say that no decision can be made by the minister which will result in Zimbabweans having to be returned to their country, because then one will argue that they've already cemented their lives in South Africa to an extent that to uproot them from South Africa is to disrupt their families, and therefore unconstitutional and infringing their dignity. And that is why then we have taken issue with the summation that the Zimbabweans have established families and everything in the country. So which suggests that there will be no decision that can be taken which will ensure that they are ultimately returning back to their country. So the dignity is an important fundamental right which is entrenched in our Constitution, but it is one that requires a balancing exercise in the context of other factors that have to be taken into account when a decision of this nature is to be taken. And that could have always been ameliorated by the aspects that I've already highlighted, which the court will have actually taken into account and even ensured that it issues the necessary directives to that effect. So that really is the submission which is intertwined with the absence of the consideration by the minister on the impact together with the limitation of rights, clause section 36 of the Constitution, which the court has found that the minister has failed to provide the necessary justification. But we've provided in our heads of arguments case law which deals with the context within which section 36 is to be applied and how justification is to be employed in the context of the limitation of rights. For instance, there was an issue about whether the minister has satisfied the court regarding the allegation pertaining to budgetary constraints. The court concluded that the minister did not go far enough to demonstrate that there were indeed budgetary constraints and did not meet the test in Rail Committee Action Group matter. But that has been dealt with in detail in the further affidavit that was filed on behalf of the minister. That budgetary constraints has always been the issue, and that has never been a question. The department requested 146 million rands, and the Treasury only made available 15 million rands. So it was clear that the budget was not available to cater for the ZEP program in such a manner that it will enable the government to continue with this program in perpetuity. Hence, then, it was necessary that a policy decision be taken on how to orderly ensure that the Zimbabweans return back to their country. So we submitted that the criticism on the absence of evidence or information regarding budgetary constraint is one that was unjustified in place on the doorstep of the minister. And of course, and the court has dealt with it in the context of the absence of the confirmatory affidavit from the minister. We know that affidavits in motion proceedings serve as both pleadings and evidence. So evidence is presented by whoever is in a position to give evidence which will assist the court. In this case, the person... Yes, Justice Malin.
Before you deal with the standing or status of the answering affidavit, in regard to consideration of the impact that the termination had on the ZEP holders, and in considering whether the conditions that brought about the institution in 2009 and whether it's ready for termination, is the court allowed to inquire into the adequacy of both categories that you've addressed the court on so far?
Yes, I am of the view that the court is permitted to inquire into the adequacy of the plan that is put in place for the orderly implementation of the decision itself. So that we make a distinction between the decision itself and its implementation. But the court, of course, then can always inquire. And if the court is not satisfied that the proper plan is put in place for the implementation, it is always open to the court under Section 172 of the Constitution to even put structural measures or structural interdict, that is, for lack of a better way. It's not really an interdict, but an injunction which will direct then the executive on providing it with a plan that it will implement in order to ensure that the implementation does not affect the fundamental rights which have been spoken about. So then that is always open to the court.
Thank you very much.
All right, Mr. Makari, you only have about another 10 minutes left. So I take it you were about to, you were going to deal with now the affidavit or the lack of the affidavit by the minister.
Yes. So I'm dealing
I
with.
think in your heads you still have the substitution. You say the court ordered gave a substitution order, and then you will have to deal with costs. But bear in mind that you only have another 10 minutes.
Yes. No, I'm able to cover all those.
Okay.
That in that time.
Thank you.
Yes. So now on the absence of yes, I've said that in motion proceedings, affidavits serve two purposes. So there are pleadings at the same time. They constitute evidence, and evidence is always given by the person who is able to provide the necessary evidence to court, which will not constitute hearsay. Because if it's hearsay, then it has to be corroborated. In this matter, what is clear is that the process leading to the termination of the Zimbabwean dispensation was or followed a process where the DG himself was actively involved by making the necessary submissions to the minister, but of course not prescribing to the minister what to do, simply making recommendations to the minister. So the DG is the person better positioned to provide the evidence as to the sequence of events and what triggered this entire process leading to the termination. And the minister's evidence, separate from that of the DG, becomes relevant if the minister has, over and above the submissions that he received from the DG, has himself then taken further decisions or altered the recommendations and made a different decision. Then he has to justify. But if the minister finds that he was satisfied with the submissions from the DG and accept them and approve them, it is not necessary for the minister to be the one who narrate that through his mouth, because that must be narrated through the mouth of the DG, being the originator of the submission. So we submit that the affidavit of the minister was not necessary, nor can one say that the evidence that has been presented by the DG constituted inadmissible hearsay. So we submit that nothing turned on the absence of the confirmatory affidavit of the minister, because the minister, of course, is a functionary that has been cited as the one who took the decision, and the minister took that decision by accepting the recommendations of the DG. So we submit that the criticism on the absence of the affidavit is one that could be arrived at differently by the appeal court, which may accept that the evidence before court was sufficient to enable the court to make a determination on the evidence and not disregard it on the basis of the absence of the confirmatory affidavit of the minister. So lastly, then we deal with the court's remedy. On the remedy, the court has given remedy under section 172(1)(b) of the Constitution and section 8 of PAJA. We submit that either the court grants a remedial relief under 172 because it has found that the review was competent under the legality review under section 1C of the Constitution, or it has granted remedy under section 8 of PAJA because it has found that the review is competent under PAJA. So the court cannot do both because the two are mutually exclusive. So the court has both found that the remedial action is appropriate under section 172 and also appropriate under section 8 of PAJA. And we submit that the remedial action could only have been competent under section 172(1)B, because the only competent review could have been one that is under the Constitution, which is legality. And the reason that we say so is because of the principle of subsidiarity. The principle of subsidiarity is that if there is legislation which gives effect to a constitutional right, one cannot rely directly on the Constitution, but one has to rely on that particular legislation. We know that Section 33 of the Constitution has given effect to by PAJA, and the PAJA is the one that remain the legislation that one can invoke if it is not a legislative act, and it can only be under Section 8 of that act, and not then under Section 172. So we submit that the remedial action that the court has made, and of course I'm alive to the fact that the only remedial action in the order itself is the one relating to what the court regards as the temporary relief, because the main relief is simply to declare the conduct unconstitutional, which that's what it did, and then from there, then it was remittal, which is the remedial action under that rubric of 172(1)A, and so it then said that the matter should be remitted back to the minister for reconsideration, in order for the minister to follow the procedure in Section 3 and 4 of PAJA. But of course, the minister cannot follow Section 3 and 4 of PAJA if the minister's decision is not one based on PAJA, or it's not one that is affected by PAJA. And we submit that if, for instance, and we are confident that the appeal court would find that PAJA did not apply to this type of decision, then it would have been inappropriate for the court to prescribe even how the minister has to reconsider the matter, and that it must do it under Section and must follow the procedure in Section 3 and 4 of PAJA. So we submit that of course is another consideration that the appeal court will have to look at. Then when it comes to Section 8(1)E, which the court said that it is entitled to grant temporary relief, of course, temporary relief is granted under circumstances where the court has satisfied itself then on the evidence that there will be substantial harm that will be caused if a temporary relief is not granted. So it means that the papers themselves must still make out a case for an appropriate interdict with those requirements, four requirements present, like prima facie right, absence of alternative remedy, irreparable harm, and balance of convenience. So those factors must still be present in order for the court to invoke its powers under Section 8(1)E to grant a temporary relief. But in any event, that temporary relief was not necessary, because we know that the minister had already taken a decision extending the grace period again until the 31st of December, and nothing really then prevents the minister from always then looking at the conditions prevalent at the time and to take a decision that does not adversely affect the ZEP members. So we submit that a lift appeal should be granted to the Supreme Court of Appeal. This is quite an important matter, as we have said, and it involves the issues that the court has already highlighted in the judgment, which I've read the judgment. And we do not wish to refer the court again to the cases that we have relied on under the case that we've relied on in our aids of argument pertaining to the appropriate remedy. Those cases then are well known. They've been referred to by the court in the judgment, and we say that those cases actually support the applicant's contention instead of the contention that has been advanced by the court in the judgment. And so those will be our submissions, unless if there are other issues that the court would like to deal with. My junior justice alerted me to the issue of cost. Of course, when we say that this constitutional matter is a matter of public importance, the court ought to have applied the bio-wash principle so that then no adverse cost order is made against the minister. And this is another order that the appeal court would come to a different conclusion, given that it seems to have been common cause between the parties that this matter does raise constitutional issues of tremendous importance. So those will be our submissions.
Thank you. Can I ask, Judge Malindi, do you have any questions?
Just one question. Thank you, my sister. Mr. Mukari, I'm just seeking a confirmation that the minister's extension from 30 June to the end of December, I think it is unaffected by the 12-month extension ordered by the court. Am I correct?
Yes, Justice Malindi, remember that the minister extended prior to the judgment of the court to 31 December, and that the judgment came and also said that the minister must do the process again, and gave the minister then 12 months and actually invoked Directive 1 of 2022 in the manner in which it protected the ZEP members. So yes, then it's correct that then it remains unaffected.
Thank you very much. Thank you, my sister.
Thank you, Judge Motha.
Yes, I have just one question. I'm not too sure if this was addressed because I got kicked out temporarily. I'm not sure, Mkari, how do you address the issue of the minister's conspicuous absence? He is conspicuous by his absence in this matter. We do not hear from the minister at all, and yet the minister is all over the news. We sure have heard the minister on TV in the extracts and reports, but we don't have an affidavit, let alone a confirmatory affidavit from the minister telling us his stance on this issue. So I'm not too sure if you've addressed that issue, but for me, that is paramount.
Yes, exactly, that's what you kicked out.
Yes.
I dealt with it, but let me just recap briefly on it. The minister is not conspicuously absent in these proceedings. He cited, and the DG has deposed to the affidavit, and that affidavit is deposed to as evidence that is relevant to the opposition by the minister. I dealt with the issue that the affidavit serves as evidence, and so the evidence of the DG was sufficient in order to deal with the processes that were followed in ensuring that the ZEP termination is done in the manner that it is done. So it was not necessary for the minister to depose to a confirmatory affidavit. So
but doesn't that amount to hearsay in as far as it relates to the minister?
No, it does not.
The minister is mentioned, and
no, it doesn't. It doesn't at all, because hearsay, hearsay operates in two ways. First, hearsay is not altogether inadmissible. What's admissible is a disputed hearsay. So hearsay which is not disputed then becomes evidence. For instance, if somebody has testified that so and so is a man, and then everybody accepts that is a man, you don't need to have that person to come and say.
But in this case, it was disputed, Mkari. Please, let's not play with words. There was a clear dispute here about what the minister intended to do. In fact, you are, I think, the second counsel of the minister. On the previous occasion, we heard that the decision had not been taken. Now we are told that the decision is taken. you really need to decide what you've done. That's why we want to hear from the minister and know what the minister's stance is all about here. We don't know. You are giving us this version, we had a different version. So when I ask you about hearsay, you are giving me a sleight of hand, talking about Section 3. I'm very much aware of Section 3, that the court can pardon hearsay, but in this case, it's disputed. Now we have hearsay confronting this court. How would you deal with that?
Yes, I understand, Justice Muta, but as I've said, that that is not hearsay at all. So we don't. So our submission is very clear that the DG has set out facts which are within his personal knowledge, and the minister's confirmation was not necessary. And also, I've heard that you said the minister is all over the news. Well, I don't watch news that much, so I'm not able to comment on that. I don't even know what he said in the news. But what I can talk about is what is in the papers. And what US justices can talk about is what is in the papers. Because I also assume you don't watch news every day. So you may have seen him on one occasion and you've missed him on other occasions where he said other things. So that's why things must be put on affidavit under oath, and then the court can deal with them.
That's Mota. Do you have any further questions? Are you?
It looks like it's frozen.
Yeah.
It looks like
The
it's
pool. Sorry,
yes.
Paul, are you there?
Yes,
Yeah,
ma'am.
just tell us what is the position with Judge Mota. His screen is frozen now.
Okay, just a moment.
Actually, it looks like he has been kicked out even.
No, he's no longer in the
Platform.
Yes, but he's sent a request now, Judge. I'm admitting Judge Mota.
Okay.
Admitted Judge Kulu.
Yes, he's back now. Sorry, Judge Mota, you got frozen and kicked out when I was being talked.
I don't know. Someone doesn't want me to hear these proceedings. But look, I won't take the matter any further. If you are of the view that it's not hearsay, we can leave it at that.
Thank you very much, Justice Mota.
Thank you, Mr. Mokari. Then is it Mr. Mojapelo?
As a court, please.
Thank you, Mr. Mokari. Mr. Mojapelo, we're only going to give you until 11:05. You can confine your argument to that time, please.
Yeah, thank you for your generosity. We didn't plan to be more than 15 minutes.
That's fine. Thank you.
The issue that involves us is very crispy. It's only 7 pages of the judgment that deals with our issue.
Yeah.
My lady and justices, the importance or the test for leave to appeal is tried, and my learned colleague has touched on it extensively. I'm going to save time and not refer to it, although it appears in our heads of argument. We are of the view, and we make this submission, that this matter in general is a very important matter. This matter raises important issues of public interest, and the angle that the truck drivers have taken in this to challenge the decision and the legalities of the actions of the minister, we submit that it raises issues which another court, a higher court, might entertain. Without repeating the test, we will submit that we will try to convince you that at the end of our argument that you must formulate an opinion that the appeal would have prospects of success. Our issue is very crisp. Our application was dismissed purely based on PAJA, the requirement of 180 days, which is clearly visible from paragraph 18 of the judgment. And we submit that by crystallizing and characterizing our application as a PAJA, the court then applied the Paja test, which we submit was a wrong test under the circumstances of the case. We state so because we submit that our case has always been based on the principles of legality, and I will refer the court to paragraph 3.3 up to 3.13 that deals with our quotations of the affidavits that clearly points to the fact that this application was never characterized as a Paja application. So the 180 days submit in terms of Paja, we submit with due respect that it is a wrong. And we proceed also by stating that our application was premised on 3 decisions. That is the 2017 ZEP decision, which will admit that there was a considerable time lapse between that time and the launch of the application. And the second decision was the December 2021 decision, that is the first extension, and the December 2022 extension. If I may just zoom on the last one, that is the December 2022, taking into account that this application, our application, the truck driver's application, was done in February 2023, even on the 180 days test, we submit that we would have succeeded. The court would have, even if it used that test, would still be obliged to deal with the merits because it was brought within 180 days. Although it is our main submission that this is not a Paja case, this is not a Paja test, it has always been a legality. On that basis alone, we submit with respect that this appeal has prospects, and a higher court might view this as an application of the wrong test, even if Paja is applicable, that the application was done within 180 days, therefore the merits should have been entertained. And on the issue of 2017 and 2021, where we clearly accept that there was a delay, we submit with respect that this court, in applying the legality review test, has discretion either to overlook the delay, and of course that discretion is being triggered by the reasons and the circumstances of the case. In our papers, it is clear that when these initial decisions were made, especially the 2017 decision was made, the Drivers Association was not yet established. And there are other reasons that we submit that the court should have used to overlook the delay, and I'll refer the court from paragraph 3.20 of the heads of the arguments up to and the following paragraphs. The difficulty in making these submissions to court on this is that the court never went into the merits because the door was literally shut when we could not pass the 180 days test. In terms of paragraph 8 of the paragraph 18 of the judgment. So it is very difficult to find what would have been the hurdle that we needed to jump in order to deal with the delay. But as I stated, and I apologize for repeating, for the extension of December 2022, there is no issue.
For the legal evidence of the legal matter who he is.
Depo, can you control the parties that are speaking out of turn, please? Either mute them or take them off the proceedings. It's interfering with the record.
Yes, I was just repeating that in any test, either legality, delay, or the PAJA delay on the last extension we are in. Therefore, the court should have entertained the merits. And then the last issue is the issue of cost. In paragraph 19, our application is dismissed with costs. And we submit, and the judgment is clear, even the submissions of the parties, no one will deviate from the fact that this application raises issues of important constitutional consideration. Of course, there's only one paragraph that deals with our costs. We do not know if there's any basis where the court has decided to deviate from the general principle. In BioWatch, although we accept that the cost issue is entirely the discretion of the court, but that discretion is to a large extent regulated and limited, especially in this type of matters, by the BioWatch principles. We do not have any explanation, any reasons why the court has decided to deviate from this principle. Of course, we are entitled to reasons, and we've stated that in our heads of arguments. Based on those submissions, we submit with respect that our application for leave to appeal passes the test, and we submit the court.
Sorry, Mr. Majapelo. Depo? Depo?
Sorry, Judge Collins, yes, I can hear you. I just wanted to alert the court. I had my mic on because Judge Mota was kicked out of the proceedings.
All right, but there are other people that are also talking, and it's causing a disturbance. Can you take these people off the proceedings, please?
Please don't
Okay,
take me
that's
out
fine.
of the proceedings.
You will know who they are, because if it was within my, if I could do it, I would have kicked them out a long time ago. I'm not going to ask you again, please.
As the court pleases, I am at the conclusion of my short address, and I hope Judge Mota did not miss much.
I don't know where he lost you. Judge Mota, can you indicate?
Yes, I lost him on course.
Okay, we're still addressing that aspect.
Yes.
Maybe just repeat.
There's only one paragraph that deals with us on cost, which is paragraph 19. And of course, we do not have any reasons of the court for deviating from the BioWatch principle. We submit that in the judgment as a whole, and clearly identifies that this is a very important issue. The parties before this court will all accept that this case raises issues of constitutional importance, and our application is based on the challenge of the minister's statutory powers in terms of the Immigration Act. And we are a private citizen, and we submit with respect that on the issue of cost coupled with other issues, a higher court or this court should rule that our appeal has prospects of success. Alternatively, that there are compelling reasons why an appeal court should sit and listen to this matter. Unless there are questions from the bench, those are our submissions.
Judge Malinde?
Thank you very much, my sister. Mr. Mujapelo, condonation is granted at the discretion of the court. What are the prospects of succeeding on appeal in overturning the discretion exercised by this court.
Yes, my lord, if condonation is granted, especially for the 2017 decision and the 2021 decisions, we submit that the facts are very clear. It's a very crisp challenge of whether or not the minister had the power, firstly, to grant those dispensation, and secondly, to grant those extensions. Because even if we lose on whether the minister has got the power to grant those dispensation, that last one, the ZEP, the minister, the act is very silent on whether or not the minister has the power to extend those. And we submit that those are, if there is no statutory power given to the minister to extend, if there's no statutory power, as we've argued in the main, to grant this ZEP dispensation, then we have prospects of success on those. The difficulty with our case is that it was not considered because, according to the court, we failed the 180 days, so that the merits were never entertained.
Thank you, my sister.
Thank you. Judge Mota, are you still there?
Oh, it appears that Judge Mota has been kicked out again.
My lady, I'm just waiting for judge to send a request to be readmitted into the proceedings.
Yeah, there's a challenge now with his fee. Judge Mota?
He's there, my lady.
Yes, I can hear you. Maybe after this submission, can we take a break and get someone to assist me with my feeding?
Okay. Did you hear the question and the response, or did you just hear the part of it? Then it can be repeated for now.
Yeah, I just heard the part of the response.
All right. Perhaps, Mr. Majapelo, apologies. Can you just repeat your response to the question raised by Judge Malindi?
Okay. Thank you, my lady. Judge Malindi raised a question to me that even if condonation is granted, what are the chances that an appeal court would interfere with the discretion exercised by the court? And I summarized our case in the merits, which the cornerstone of our case is the statutory power that we submit that the Minister of Home Affairs does not have, never had to create the ZEP dispensation, that is the 2017 decision, and never, the Act is also silent on whether or not those dispensation can be extended. We are making a submission on the extension because even if we are wrong, even if it's found that we are wrong on the submission that the minister does not have a power to create the ZEP dispensation, the Act is silent on the power to extend those. So we submit that even if this court, the appeal court, would be inclined to interfere with the discretion of the court, this court, in our submission.
Okay. Thank you, Mr. Majapelo. Judge Mota, do you have any questions to pose to him?
No.
Okay, thank you, Mr. Majapelo. You kept to your time.
Thank you, my lady.
Thank you very much. So can we take a 10-minute adjournment or so, and then we'll reconvene at 11:05. And this is now with the arguments for the respondents.
Yes.
All right, thank you.
Thank you.
May it please the court.
Thank you.
Recalling case number 32323 of 2022. That's the Minister of Home Affairs, the Director General of the Department of Home Affairs and All Truck Drivers Forum and Allied South Africa versus Helen Suzman Foundation and the Consortium for Refugees and Migrants in South Africa. May it please the court.
Thank you. Ms. Steinberg?
My lady, my lords, this is indeed a matter of great importance and public significance, but that is not enough. The test is the prospect of success. It really begins and ends there, whatever the nature of the matter. In our heads of argument at page 4, paragraph 12, we set out the test, and there has to be a truly reasonable prospect of success, and that's a quote. Another quote is, a realistic chance of success on appeal, a mere possibility of success, an arguable case, or one that is not hopeless, is not enough. So that is really the simple question before this court. Is there a realistic prospect that another court might come to a different conclusion? Paragraph 22 of our heads, page 7, we then actually quote the SCA, which says that the prospects of success remain, quote, a vitally important consideration in considering compelling reasons. The lack of prospects is often decisive. And really, in short, our argument is that there are actually 0 prospects of success in this case. And this is why. Contrary to my learned friend, Mr. Makari's submissions, this issue does not raise a matter of constitutional importance. It's constitutional and admin law 101 with respect. It is the first principle of natural justice, audi altrum partem. It is common cause that this decision impacted on the lives of 178,000 people and their children. And of course, all the South Africans whose lives are inextricably bound up with the 178,000. And in law, there is a watertight obligation to hear what affected people have to say before a decision impacting on their lives is made. It is the first principle of natural justice. It's common cause that the minister did not, in fact, hear from the affected people before making the decision. He called for representations later. Now, it matters not whether Paja is at play or the principle of legality is at play, because both cover the question of audi as a founding principle. Likewise, whether it's section 3 or section 4 of Paja, it matters not. People affected by decisions have an ironclad right to be heard before the decision is made. And as Justice Motta pointed out during the case itself, the rationality, procedural rationality, takes us a long way. We don't even have to go a long way. This is audi. And with respect, that is the beginning and the end of this case. There is no court in South Africa that would ever say that the minister is entitled to make a decision which profoundly impacts on the lives of many, many people without hearing from them first. You know, the Constitutional Court recently found in the ETV case that a decision was irrational and procedurally unfair because it affected people's right to watch TV in the ETV case. This affects people's whole lives, where they live, where their children go to school, how they earn a living. There's no question that arises that any court would entertain. And Justices, you will be aware more than I that the SCA on repeated occasions has frowned upon high courts granting leave to appeal where there is just no prospect of success. And our submission is that there really can't be. The question as to who made the decision. The DG's memo to the minister gave him options. It can be 12 months, 3 years, you choose. He chose 12 months. He made the decision. As Judge Morter pointed out, there's now a new case on appeal, which is impermissible, that he did in fact make that termination decision. The point is, though, that this court handed down judgment on the basis that he did make a decision. That ground is covered. This court treated the matter that the minister made a termination decision, a final decision, and the court was emphatic on that. Now, again, Admin Law 101, the minister makes the decision. The minister is required to apply his mind. And there is no evidence that he did. The question of the plan made pursuant to the decision and the orderly conduct of how the process of the Zimbabweans returning to Zimbabwe it just doesn't arise, because there's no evidence that the minister applied his mind to the antecedent decision. My lady, my lords, since this court handed down judgment, the Supreme Court of Appeal handed down judgment in the case of Full versus the JSC, which is quoted in our heads. And that case concerned the impeachment of Mutata. And in that case, as the judgment tells us at the evidence that was adduced on behalf of the JSC was from the secretary of the JSC. He deposed to the affidavit. And no one who sat on the JSC in the disciplinary commission, the disciplinary committee of the commission, made a confirmatory affidavit. It was merely the evidence of the secretary. And he said the facts are within my personal knowledge and are true and correct. And they said, well, at paragraph 27, I'm going to read the paragraph. The SCA held, had the JSC merely participated with a view to placing the record of its deliberations before the court to assist in consideration of the matter, there could hardly have been any objection to Mr. Chilwani deposing to an affidavit for that purpose. Not so once it decided to oppose the application. As a lay witness, it was simply not open to him to depose to all manner of opinion evidence. Now, the parallel in this case is not opinion evidence, but it was a decision to which the minister had to apply his mind. The DG did not have to apply his mind. The minister had to. And the court goes on to say in the same paragraph 27, Mr. Chilwani's affidavit was not accompanied by even a single confirmatory affidavit from any of those persons with personal knowledge of the facts. The High Court approached the evidential material proffered by Mr. Chulwane in his affidavit as if it constituted proof of the truth of the matter so asserted. In that, as counsel for the JSC accepted at the bar in this court, it erred. For my part, I am willing to pass over the issue because on the view I take of the matter, even on the JSC's own showing, the decision of the majority does not survive scrutiny. In other words, the court is saying, had the decision actually survived scrutiny, we would have we would have found against the JSC on the basis that there was no evidence submitted to this court. But since even if we accept their answering affidavits and their submissions, it doesn't survive scrutiny. We'll look at it. And the court did so because in that matter, it was the first time the SCA had ever dealt with the test for impeachment and felt that it was very important to do so. Now, I submit that this case is on all fours with that JSC case. This court could begin and end the case by saying there is no evidence that the minister applied his mind to this case. If the court chose to, it could go further to say, well, even on the merits, it doesn't survive any scrutiny because the facts, the common cause facts, are that the minister heard from nobody and the department heard from nobody before it made a decision with profound impact on the lives of hundreds of thousands of people. And again, that is the end of the case. And there is no prospect that any other court in the country could possibly find otherwise.
Ms. Steinberg,
Yes, Judge Malindi.
if you could assist me there, did the SCA then proceed on the basis of common cause facts, excluding the affidavit, the evidence in the affidavit, or in consideration of what has been rendered common cause facts, including the affidavit?
The court said at certain points, even if we accept the evidence of the JSC, so it qualified it. It was saying we shouldn't, but even if we accepted it, we still find that the JSC has no case. So it was saying we don't accept it, even if we did, and we only do for the purpose of creating precedent for the lower courts. I mean, that's the implication. The judgment doesn't say that. But it says this matter is an important enough one and it's a novel enough one for us to at least begin to lay out the test for the impeachment of a judge, because it hasn't been before us before. But it's very clear that it did not accept that evidence.
So does it mean that in this case, we could say we grant leave because of the common cause understanding that this matter is of great importance, and maybe the SCA acting as it did in Full versus JSC may take consideration of what may emerge as common cause facts?
Judge Malindi, I think you could. But my submission there is, let's assume the minister had deposed to that affidavit. There are no reasonable prospects of success that any other court could say, absent consultation, the minister was entitled to make this decision. And that is our primary submission, that actually it makes no difference at the end who deposed to the affidavit. There is no case.
Thank you very much. Thank you, my sister.
Yes.
Thank you.
Now, on the question of relief, Mr. Macquarie will correct me if I'm wrong, but he seemed to submit that Section 172 of the Constitution and Section 8 of PAJA created different regimes for remedy. And my lady, my lords, that is not the case. And I will read the court one paragraph in the All Pay case, which put this matter to rest. The reference is 2014, Volume 1, SA 604 CC at paragraph 25. And the court said, and I quote, "Once a ground of review under PAJA has been established, there is no room for shying away from it. Section 172(1)A of the Constitution requires the decision to be declared invalid. The consequences of the declaration of unlawfulness must then be dealt with in a just and equitable order under Section 172(1)B. Section 8 of PAJA gives detailed legislative content to the Constitution's just and equitable remedy." With regard to costs, my lady, my lords, Mr. Macquarie relies on BioWatch to argue that the minister should not be burdened with costs. With respect, the principle in BioWatch does not exist to protect the state from costs. It exists to protect litigants who wish to challenge law or conduct. And paragraph 3 of paragraph 23 of BioWatch is very clear in this regard. And paragraph 56, 23 and 56. And they're long paragraphs. I'm simply going to read one sentence. It says, "If there should be a genuine non-frivolous challenge to the constitutionality of a law or state conduct, it is appropriate that the state should bear the costs if the challenge is good." It says, in this way, responsibility for ensuring that the law and state conduct is constitutional is placed at the correct door. So there is no case in which a court has applied the BioWatch principle to government's costs, because there can never be a chilling effect on government in defending its conduct or law, because the state has a budget and needs to have a budget to defend its conduct and its laws. BioWatch exists for litigants, NGOs, etc., to allow them to challenge this conduct and law without fear of being burdened with costs. With regard to Mr. Mojapello's submissions, nothing Mr. Mojapello can say can overcome our main submission, and that's that the minister made a decision of great import on people's lives without consulting. And there is, in fact, no third party that can ever be heard to say anything that can change that. So whatever happened or didn't happen to his client does not change the prospects of success on appeal. No full bench or the SCA is going to say it's okay to make a consequential decision without consultation. With regard to the costs order against his client, I merely remind the court why the buyer watch principle is not applicable there. And that's because Judge Davis recorded that he allowed the intervention of that party on a very narrow basis. And that was, merely to provide an affidavit to support the submissions. But what they did in defiance of that order was to launch a whole counter application. And this court correctly dismissed that with costs as vexatious. It was a waste of the court's time. And it was contemptuous of Judge Davis's order. And of course, BioWatch, in fact, explicitly says that where a challenge is frivolous is the word they use. Of course, vexatious or irrelevant in any way, the principle would not apply. And we submit it's as simple as that. And just to remind the court, there was no condemnation application before the court. There was no discretion involved. And unless the court has other questions for me, really those are our submissions. We say we're not going to re-argue our case. We say that there cannot be a more open and shut case. Then Audi's required, common cause, Audi wasn't afforded, end of story. And the details really matter not. Paja, Constitution, which section, it really doesn't matter.
So the case for the well, at least the first applicant is that the respondent here rather is that the court should refuse leave to appeal
With costs.
with cost. Judge Malindi, any questions?
None at all. Thank you, my sister.
Judge Motam?
Yeah, I have a few questions, maybe just one. Having listened to all the parties and also having read the judgment, the inescapable conclusion is that everyone is at ad idem, that this is indeed a matter of great importance and of great public importance. Now, if that is our starting point, then it takes me straight to section 17(1)(a), Roman figure 2. In this respect, I wish to refer you to the case of the Minister of Justice and Constitutional Development, this is Southern African Litigation Center and others. It's a 2016 decision, 3SA 317. Where I want to take you, it's page 329, paragraph H. The court is dealing with the, I think you muted.
Judge, would you give us a moment just to get there so that I can follow with you?
Yes.
One of you pass me a... My Lord, did you say paragraph 23?
It's page 329, paragraph 23. Yes.
I'm with you.
You with me? Yeah, it gives me a sense of ambivalence as to where one should go with this matter. Let's go to, I'm quoting now, under H, but it failed to consider, I quote, it failed to consider the provisions of section 17(1)(a), Roman figure 2 of the Superior Court Act, which provides that a leave to appeal may be granted notwithstanding the court's view of the prospects of success. Let me just pause there. we have our view on the prospects of success, and I think I'm in agreement with you as far as that is concerned. But then if you go further, now it ties in with what I started off with. The usual ground for exercising that discretion in favor of dealing with it and the merits is that the case raises a discrete issue of public importance that will have an effect on future matters. That jurisprudence should have been considered as a guidance or guide to whether, notwithstanding the High Court's view of an appeal's prospects of success, leave to appeal should have been granted. In my view, it clearly pointed in favor of leave to appeal being granted, close quote. Now, that worries me, that we shouldn't lose sight of the importance of this case, and maybe a higher court needs to have a look at it, maybe also tying in with Justice Malindi's proposal. What's your comment on that?
Lord, a compelling reason. My submission is that the fact that the matter is important is not enough on its own. The rest of paragraph 23 says that this is linked to the question of mootness. In that regard, there is established jurisdiction in this court that even where an appeal has become moot, the court has a discretion to hear and dispose on its merits. The usual ground for exercising that discretion in favor of dealing with it on the merits is that the case raises a discrete issue of public importance that will have effect on future matters. That jurisprudence should have been considered as a guide to whether, notwithstanding the court's view on prospects of success, leave to appeal should have been granted.
The fact that it dealt with mootness just fortifies what I'm talking about. Here we're not dealing with the matter that is moot. Okay, we've arrived at, well, when we say we arrived, some might not have arrived at the conclusion that there might not be prospects of success. But despite that, there's also another element which this court needs to look at. Now,
Yes.
at least that's there.
Yes, my submission in that regard is that the overall issue of the fate of the 178,000 permit holders is, of course, an issue of enormous public importance. But the legal issue to be decided is not. And my submission is, it's not for this court to say that because the subject matter is important, the court needs to lay down guidelines as to how the matter should be followed. There is no debate on the guideline. This is not a new issue. It's not an issue of constitutional or administrative law that a court needs to give guidance on. It's Audi. So the parallel being the Motata case, the court, and I speak merely of an analogy, the court said we don't need to go any further than the fact that that there was no affidavit from the JSC. We will, because it's of public importance, to start to define a test that doesn't exist. So
Councillor, let me just press you on this, because I think it's important. It doesn't talk about legal importance. It says public. It's of public importance, an issue of public importance, and it's no less a court than the SCA. So that is important that we take into account.
Judge Mota, my submission is that it cannot be, however important an issue is, that when the actual issue of law is open and shut, that the SCA would want to give its time to it. That the issue must be one of public importance that requires the court's guidance. But one must be able to read, otherwise the SCA will be burdened by cases that don't require, the public doesn't require the courts to say anything about them, regardless of the subject matter, because the legal principles involved are 101. So my submission is that the proper interpretation of what the court says is, let's assume there are no prospects of success, but the court's judgment will be terribly important in future. It's moot, no prospects of success, whatever, but the court's judgment will serve the public interest in the future. Then there is indeed a compelling reason. But how can there be a compelling reason for the SCA to say, well, our law starts with audi alteram partem? My junior is pointing me to another SCA judgment. Would you give me one moment just to see what he's giving me? He's much cleverer than me, so I'm sure there's something. It's a judgment that Karatko, which is referred to in our heads, and it's a 2020 case, paragraph 2, and it says, in order to be granted leave to appeal in terms of section 17(1)(a)(1) and 2 of the Superior Courts Act, an applicant for leave must satisfy the court that the appeal will have a reasonable prospect of success, or that there is some other compelling reason why the appeal should be heard. If the court is unpersuaded of the prospects of success, it must still inquire into whether there is a compelling reason to entertain the appeal. A compelling reason includes an important question of law or a discrete issue of public importance that will have an effect on future disputes.
There you go. In fact, you might be hosted with your own petard, because if you look at it, it cuts nicely in the middle between matters that relate to law and matters that relate to public importance.
But with respect, my lord, the end of the sentence, it says, a discrete issue of public importance that will have an effect on future disputes. Now, and just to finish it, but here too, the merits remain vitally important and often decisive. Karatko must satisfy the court that it's met this threshold. So that is precisely my submission. Even if there are no prospects of success, the merits remain vitally important. Why? Because if the matter is going to have an effect on future disputes, then there must be merits that require the court's guidance, that require the court's decision. So properly interpreted, yes, a compelling reason can exist in a case where there are no prospects of success or where the matter's moot. But a compelling reason is not an issue of public importance per se. It's an issue of public importance where the merits of the matter are such that they require the court's judgment. Now, our submission is that this matter does not require, the subject matter is important, but the court's judgment is not required. The SCA does not have to waste its time because the court's guidance on future matters is not required. The SCA doesn't have to tell government that it must consult people before making decisions. It would be a waste of the SCA's time. to do so. And the subject matter matters not. It's an ironclad principle. And the judgment would be of no value to anybody if the court just had to say that. So
Thank you. I
Yeah.
have no further questions.
Yeah.
I think we've exhausted the topic.
So just to conclude, compelling reasons is not synonymous with an important issue in the layperson sense. It's synonymous with an important issue in which parties need the court's guidance. Otherwise, why would the court, our under-resourced, overburdened courts need to worry? Those are my submissions. Thank you.
Thank you, Ms. Steinberg. I think let's give an opportunity to Mr. Simmons.
Thank you, milady. Unsurprisingly, I will be echoing in part certain of the submissions and overall contentions made by HSF. I'm going to endeavor not to repeat unnecessarily, but rather to supplement those submissions. But the core of our argument before this court remains the same, which is that neither of the applications for leave to appeal should be granted. They should be dismissed with costs, both because in the case of the application of the Department of Home Affairs, because it has no prospects of success, and also because we would submit there are no compelling grounds in which to consider it. Regarding the truckers, the application of the Truckers Forum, which I will deal with at the end of my submissions, we would submit the court made the correct decision regarding delay, and there too, given the higher standard applying to the court's exercise of its discretion in that regard, there are no prospects of success. I'm alive to the debate that Justice Morcha has had about this question of compelling grounds, and I intend to get there. But first, as it were, to frame part of that debate by dealing with certain aspects of the argument on the merits. We concur wholeheartedly with Advocate Steinberg SC when she said that this is Admin Law 101. The principles at issue in this matter. And we would submit that's what this court had in mind when it started its judgment by saying that this is a matter of public interest and importance, but also of very simple, straightforward principles of law that in no way need to be developed or expanded or even disputed in any meaningful sense for us to achieve the result that this court has reached. So we concur. There is no prospect of that underlying difficulty, particularly the Audi difficulty, being overturned by any appeal court. But to move on, let us suppose that there was some merit to the submissions by the Department of Home Affairs, the applicants in this application, to the idea that ex post facto submissions or representations could be made by ZEP holders and by entities such as my client. Well, they provide no precedents or examples of how that would work, and nor do they engage in any significant sense with the reasoning provided by this court on the Motau judgment, the application of why this matter is administrative action. But we don't even need to go that far, because even on the principle of rationality, which is common cause, there needs to be a fair opportunity to affect the mind of the decision maker. And again, even if we grant the department the benefit of the doubt on those submissions, we come to the difficulty of the closed mind of the decision maker, i.e. of the Minister of Home Affairs. And there, as was raised earlier this morning, there's the difficulty that there is no affidavit of any kind from the minister. And the minister has been quoted on record as indicating that he has made up his mind on this issue. I appreciate the court dealt with this in its judgment at length, and I won't be re-arguing that case, but just to perhaps illustrate by quoting one piece of correspondence that the minister had with the Scalabrini Center. It was placed on record in this case in the affidavit of Mr. James Chapman, and I have hopefully referred the court to the correct case lines page, which is 018294.
Yes, thank you.
Yes, the Scalabrini wrote to the minister and inquired, can we ex post facto engage with you on this decision? And the court will see there the underlined section, there is no scope for reconsideration as the decision was taken after careful consideration and supported by the National Executive Cabinet. It has become practically impossible to continue with the exemption regime. So even if there was some way of granting Audi ex post facto, there cannot be in circumstances where the decision maker has indicated this kind of a perspective. And then even if the minister could have perhaps on affidavit have convinced the court that this was not in fact his overall view, we have the difficulty that there is no affidavit from the minister, nor with respect is there any convincing reason why there is not. The suggestion was made earlier this morning by counsel for the Department of Home Affairs that, you know, the minister was, sorry, the Director General was actively involved, and therefore him and the minister are, you know, more or less one and the same. But with respect, that is not our law and has never been South African law. There's no precedent for suggesting that a person who makes a decision can then allow another functionary to defend that decision. And I must add two nuances to that. First is, of course, perhaps, and I say this hypothetically for the sake of argument, the Director General did know the minister's reasoning behind the impugned decision. But this question of, does the minister have an open mind? This question of this letter that we have just quoted to the court, the DG has no particular insight into that. He had no role in that letter. So he cannot make any comment on that. And secondly, I must point out that this is not a case where, you know, in which the policy and the reasoning and the outcomes of these decision makers, the minister and the Director General, are completely one and the same. It bears mention that the minister gave a number of reasons for his decision, including the court may recall that it'll have a positive impact on unemployment and that there had been ZEP holders who were found guilty of misconduct. Those were two of the reasons given by the minister in his decision. I'm not taking the court there because it is, I don't want to re-argue our case, and I don't want to take the court into that unnecessarily. But those were abandoned by the Director General in his affidavit. So the point is, this is not a matter in which the person who's claiming to speak on behalf of the minister does so in an obviously correct fashion. On the contrary, he has attempted on his affidavits and in giving his reasoning and his explanations to change and amend and retrofit what the minister has said. And let's also perhaps end this point by begging the question why there is no affidavit from the minister, given that there has been ample opportunity for such to be placed before this court, and little more than a confirmatory would have been required to rectify this difficulty. And yet, despite the minister's decision being challenged, despite the high profile of this matter, despite all the opportunities given to him, he has not presented evidence under oath to this court. And there are consequences to that kind of an election, including that his decision must now fall and is beyond rectification on appeal where that evidence cannot arise. So we would submit that on those grounds, on the basis that the Audi point is inarguable and inescapable, even on the evidence before this matter, there is no prospects of success. I would add that there was an attempted suggestion that this matter was policy-laden, that it was polycentric, and therefore that there should be an appropriate degree of deference by this court to the decision of the minister. But with respect, those submissions which appeared in the Headsby based on inapplicable judgments do not affect the underlying nature of the Audi argument. This court was not going to the heart of polycentric disputes and all of those matters. The court was saying, follow a fair process. Do the basics required when you are potentially depriving 178,000 people of their rights, of their homes, of their jobs, of their children, of their schools. Offer them an opportunity to be heard. That injunction placed upon the minister does not change at all with regards to whether it is a case that affects one person or a case that affects 100,000 people. I must add that, to my knowledge, there's no judgment which suggests that a case where, which affects more people is inherently unlikely to be regarded as administrative action. I believe in the heads of argument of HSF, they've referred the court to judgments in which withdrawals of exemptions and decisions under the exemption provisions of the Immigration Act were regarded as administrative action. One of them was the case of Director General of the Department of Home Affairs versus De Souda attorneys. And that was a case where hundreds of matters had been, under the Immigration Act, had been unfairly delayed. But that too, unquestionably, was regarded as administrative action. And we may also have regard to other cases of, that are well known, such as the outer judgment, where the e-tolling issue was taken before the courts. In that judgment, the famous judgment is the one concerning the interim interdict, and the court in the Constitutional Court in that judgment emphasized the severe impact it would have on the fiscus and on the sort of the budgets of the state if the interim interdict was upheld. But it's the court stated, and there was never a dispute, that Haja applied. In fact, one would suggest that the more, the greater the number of people whose rights are affected, cannot be served as a basis to afford them the lesser protection that might arise under the principle of rationality. So, but to summarize those submissions, then we would say, I beg your pardon if there was a question. No.
No.
I beg your pardon, there's a jump in the video feed. We would say that there's no prospects for success. That then takes us to the question of compelling grounds. And there too, Justice Mota has heard, or the court has heard from the submissions about the interrelationship of these two factors. And we concur with counsel for HSF that there must be some minimum level of prospects of success for leave to appeal to be granted. We would perhaps submit it's almost like a sliding scale. In a very important matter, it may be that you can do with less of prospects of success, because it's important that one gets it right. But if there are no prospects of success, then it goes no further than that, is the beginning of our submission. We would take it further though and look at the particular circumstances of this matter. This is a matter in which the nub, the practical effect, and I'm emphasizing practical effect because based on what we've said already, there are no legal precedents to be set in taking this matter on appeal. There's no new law to be made, to be developed in that sense. But perhaps the argument might be there's just a lot of people involved here and they need to have the right decision made for them. But the practical effect of this court's judgment was not to permit the ZEP to be continued indefinitely, nor even for a particularly long period, bearing in mind that it has operated in one sense or another since 2009. The court sent this decision back to the minister. It put in place an interim regime which will protect these individuals for plus minus a year, but a year of an extension is not that big bearing in mind the 14 years this matter that these exemptions have been in place, and bearing in mind that the minister himself has repeatedly made extensions first of a year and then of 6 months onwards. So if the question is we need to obtain the correct outcome for these people, then with respect, the path is a clear one. What the minister should do is take the opportunity afforded to him by this court to follow a lawful process and make whatever decision it is that he chooses to make, once he takes into account the just and proper submissions and representations of those affected. That is the proper way forward. In this matter, I think there have been approximately 3 extensions of the ZEP since since the termination decision.
Mm.
That illustrates how we would submit how simple and the minimal impact on the public of granting those extensions. That's different from when one ends the decision. A decision to terminate rights, to evict someone from their house or to place someone in prison, that is the violation of rights that very often calls for full-on assessment by the appellate courts or proper, full reasoning, because the infringement of rights there is so patently severe. But the practical import of this court's decision is not that at all. It is to allow for a short time the continuation of a system that has existed for over a decade, which the minister himself has repeatedly extended, so that a fresh decision following a lawful process can be made. With respect, that is the proper outcome for a matter such as this. So we would submit that there are no compelling grounds for this matter to be considered on appeal. There is nothing that pragmatically calls for the correct decision to be made, because this court's judgment is not the end of the road on this process, and the minister has still got his powers to consider it further. Those being my core submissions on the case of the Department of Home Affairs, I would perhaps move to make a few brief submissions concerning the Truckers Forum, subject to questions by the court. But
I think you can proceed with your argument. If there's any questions, we can ask it in the end.
Thank you, Justice Collins.
Yeah.
Briefly then, Justices, we concur. I think the point has been made that in arguing against a finding of unreasonable delay, the standard that any potential appellant would meet is a high one. And with respect, we say that the forum here does not meet that requirement. The nub of the argument appeared to be that this court failed to consider the common, that it may be an application under the principle of rationality to review the impugned decision, and that this court limited its reasoning and its conclusions to applying the Paja test. But with respect, we submit the court didn't do so. There is a slight formatting issue that may be relevant here, Justices. I'm going to refer the court to paragraph 18 of this court's judgment, which is the key paragraph concerning the delay finding. Just waiting for it to load.
Are you taking us to the Khumalo test? I think we did deal with that. We are aware of that.
Thank you, Justin. Yes, I mean, I know you were, but I just wish to point out, if I understood, and I may have missed it, but there was a repeated suggestion that this court didn't deal with unreasonable delay under the principle of rationality in its judgment. And I just wish to point out that in what appears to be the quote at this page, the quote is in fact just the first 3 lines, 3 to 4 lines. And then there is reasoning by the court itself, where the court says there is no application for this court. Accordingly, the forum has failed to comply with Paja. Critically, then, the court says, furthermore, this court is of the view that a period of over 2 years is an unreasonable delay, especially when there are no reasons justifying and explaining the delay. So I simply wish to draw that to the court's attention. The court did explicitly make this point. Then regarding the 2 more points, Justices. The first is that even if the Truckers Forum were potentially able to make submissions on this point, they would have had to have made out a case for condonation of their delay in their founding papers. And it bears mention again that nowhere in their founding papers, whether under Paja or under the principle of rationality, is there a case made out? So they too fail on rather trite principles of law. In this case, that one must make out one's case in the founding papers. And then lastly, justices, with regards to costs, again, I echo Advocate Steinberg SC when I say that the Truckers Forum have essentially brought a second case into this matter. They brought a counter application, they brought new arguments, they have necessitated the separate filing of heads of argument, this preparation of separate, arguments and legal research. They have dramatically expanded the scope of this matter, thereby inflicting costs on the applicants. And if they enter a matter as respondents and they are unsuccessful, then the ordinary order should apply. And there is nothing in Biowatch or any other judgment to which the court has been referred which suggests anything different. So we would submit that both applications fall to be dismissed with costs. Those would be my submissions, justices.
Thank you. Judge Malindi, do you have any questions?
And none at all, my sister. Thank you.
Thank you. Judge Mota?
None, my sister. Thank you.
Thank you, Mr. Simmons.
As the court pleases.
Thank you, Mr. Makari. Your reply? Mr. Makari, can you hear me? I think Mr. Makari is frozen now. The pool.
I'm glad it's not me.
I'm also glad it's not you. Let's just give him an opportunity to maybe log on once again. Shall we just take an adjournment for 5 minutes or so? I don't know. There's no response. We'll stay online. You can just take our video feed off.
I will inform the court once counsel is back on the platform, Judge.
Yeah.
Advocate Makar.
Yes, I'm here.
Counsel, can I just ask that you please switch on your camera? Okay, thank you, Counsel.
Yes, no, thank you. I'm sorry, I got kicked out when I was about to start after Mr. Simmons finished.
Yes, noted, Counsel. May it please the court?
Thank you. Are we all back?
Yes, Judge Chris.
Mr. Makari? Can you hear?
Yes, I'm here, my lady.
Okay, thank you. You may reply then.
Thank you. First, let me deal with the sensational submission that there is some administrative law 101 looming here. There is none. There is a very important matter of public importance which raises serious constitutional issues. But the respondents seem to suggest that this matter revolves revolves around Audi, and that Audi is a one-size-fits-all. They say no Audi, no decision. That is not Administrative Law 101. Administrative Law 101 is to the effect that Audi is adapted to the circumstances of every case. So Audi pre-decision and Audi post-decision, both of them fall under Administrative Law 101. So the point here is that we say that there was Audi, it was Audi that was adapted to the circumstances of the case. Now, my left friend for Helen Suzman Foundation referred to paragraph 27 of Freedom Under Law versus Judicial Service Commission is a very recent case of the Supreme Court of Appeal, which involved the impeachment of Justice Motata. Fortunately, then my learned friend who appears with me here was involved in that matter. And we actually submit, in consonant with the issue that was canvassed by Justice Malindi with our learned friend, that when one looks at what the court said in paragraph 27 regarding the admissibility of the affidavit that was deposed to by the Secretary of the Judicial Service Commission, who was not even sitting in the panel which was involved in the entire process pertaining to the disciplinary processes of Justice Mutata, and expressing opinions. The court said that that evidence will be inadmissible. But in this matter, the affidavit that is being filed on behalf of the minister deposed by the DG stand in direct contrast to the status of the affidavit that the Supreme Court of Appeal dealt with in the Judicial Service Commission matter. So here, the affidavit of the DG was found to be inadmissible because it is littered with hearsay, but we say that actually the affidavit of the DG was an affidavit of the person with the necessary evidence that he was able to place before court. So Justice Malindi's intimation with our learned friend is quite opposite if one were to take into account that then if the appeal court is going to pick the evidence which is in the affidavit deposed by the DG, then the different outcome will ensue. And so that alone is sufficient for this court to find the prospect of success and grant leave. There was also a submission in respect of the assertion that we have said that there is a clear distinction between Section 172 1B, which deals with just and equitable order, and Section 8. Yes, there is a clear distinction, and the reason is that they are found in different legislation. The other one is in the Constitution, which is the source of the one which is in part. So Section 8 is the offshoot of Section 172 of the Constitution, and it elaborates on the powers of the court when it grants remedial orders under PAJA. And the court, of course, can still do so under 172 if it doesn't go under PAJA. But here we know that the court has gone both under PAJA and also under the Constitution, which is section 172, which we say that it is mutually exclusive. So that is a submission that we are making. I'd like to refer also to what I've mentioned regarding the right to be heard, that it is adapted to the circumstances of each case, and one has to determine whether it is done under PAJA. If it's done under PAJA, then it is procedural fairness, and if it is done under legality, it assumes a different nomenclature altogether. In Albert, which both parties have referred to it, is a case which dealt with the pardons to the perpetrators of the apartheid crimes in the TRC. The president seeking to pardon those who were then perpetrators and who have applied for amnesty. And the court, there's a constitutional court, found that although that was done not under PAJA but as an executive function, but in such circumstances, and that's very important, in such circumstances where you have got the victims, then the president will have to take their views into account. So that's really then the context in which the right to be heard, or AUDI, is always treated, because it has to be adapted to the circumstances of each case. So we submit that Justice Motra, there are prospects of success on the merits. So I'm saying so, Justice Motra, because of the views that you have expressed, that there are no prospect of success. And we accept that the court has not made a decision on that point, because we've got 3 judges. But I'm just addressing you to say that there are prospects of success on the merits. But agree with Justice Motra on the second part, which is Roman figure 2 of section 17, where you engage with our learned friend in respect of where there is compelling reason why the appeal should be heard. And correctly so, the judgment that you have identified for the benefit of our learned friend, which is actually the Al-Bashir judgment. It is the Al-Bashir matter, where the SCA, after, and remember that what we are reading to then to our learned friend, it was the judgment of the SCA after the High Court, after the full court of the High Court refused to grant leave. And it was in that context that the Supreme Court of Appeal stated what it said in paragraph 23 of that judgment. So the importance of the matter, the public importance of the matter, the discrete issue of public nature, which requires the attention of the court, all those are factors which are important for the court to grant leave, even if it is not persuaded that the prospect of success are there. Of course, my learned friend has identified correctly that the Supreme Court of Appeal has also, in order to guide the courts that consider whether leave to appeal should be granted, to say that you do not simply say that because you have found a compelling reason you grant leave, even if the merits are not considered. You must still consider the merits. That's why I said the merits still remain vital. But remember that when you say that the merits remain vital, you have already formulated a view as a court that there are no prospect of success. So there is nothing like a half prospect of success and full prospect of success. You must look at section 17(1. It talks of prospect of success and full stop. But the merits still remain vital. So which means that you still have to take into account that are the merits upon which then the Court of Appeal will base its decision. If there are no merits, of course, then you don't have to go to consider Roman figure 2. So we agree with you absolutely on that point. And we say that our leave to appeal is grounded on both legs. One, Roman figure 1, process for success. Roman figure 2, compelling reasons. And we say that there is more than ample compelling reason why this must be considered. And our learned friends have simply shied away from the submissions that were made regarding the policy-laden type of the decision. And we say that we are saying that our authorities Mutau versus Minister of Defense, and that is a constitutional court judgment. So those are submissions that leave appeal be granted to the Supreme Court of Appeal, and with cause to be caused in the appeal.
Any questions, Judge Malindi?
Thank you, my sister. Mr. Mukari, somewhere in your submissions, you say that the Court of Appeal could come to a different decision on the basis that the failure to give Audi was ameliorated by giving such Audi to the individuals after the fact and engaging with some of the organizations. If I'm correct, that's your submission. Have you given us authority for that submission?
No, but what I feel was in consonant with decisions which affirm that Audi can be given even after the decision has been made in order to persuade the decision maker to alter the decision. So hence I was saying that the Audi post, it was Audi in order to persuade the decision maker otherwise, but the amelioration was already there when the minister reached out to the affected persons, not to the public, but the affected persons. Hence, I'm likening this case to Albert, where the interested persons were the victims. So here, the interested persons are those who are affected by the decision to terminate the ZEP. And they were given an opportunity, and we received over 6,000 of those submissions.
Thank you. No further questions, my sister.
All right. Judge Mota?
I have no questions. Thank you, my sister.
Thank you, Mr. Mukari. Thank you.
Were indebted to the court.
Mr. Mojapelo? Your reply?
Yes, as it may please you, my lady, I hope to be as short again.
Thank you.
Yes. The first point that I want to deal with is the point by the counsel for HSF, where there seemed to be a suggestion that our application, our counter application as a respondent is contemptuous of Judge Davis' order. Judge Davis' order admitted us to these proceedings as respondents, and it will be, I mean, it won't be an acceptable practice for an order, for a court order to admit a party and not restrict their rights. A respondent is a respondent, can launch a counter application in terms of applicable rules. You cannot simply just be a respondent and not be able to make applications. So the order says, which is the order says the application by all truck drivers and allied South Africa to intervene in the main application is granted, and it is joined as the third respondent therein. And then a 3 says the aforementioned third respondent is directed to deliver any answering or supplementary affidavit it may wish to deliver in the main application within 10 days from the date of this order. No one can read this affidavit to say it restricts the respondent from exercising all the rights that the respondent have as parties to an application. And it was clear in the application, the basis that we asked Judge Davis to include us was to challenge the minister's power to issue the Zimbabwean permits dispensation. That was the only basis. And that would have not appeared from it has appeared from the application. When we are parties now, then we amplified our argument, but it's still the same. We are challenging the minister's powers to grant this Zimbabwean exemption. To suggest that such an application is contemptuous is, with respect, not correct. On the issue of costs, which is usually the last part, but I'm dealing with it now. There was a suggestion that our application is frivolous. There was also a suggestion that this application is, admin law 101, and I don't know whether that should, in the principles laid down in deprive us of costs. As we've argued in the main, that there is no reasoning of the court why the by-watch principle was deviated from. The submissions that will be made on behalf of the respondents today is simply to write a new judgment, because there are no reasons. In our heads of arguments, we've dealt with the principles that we are entitled to reasons, especially as the losing party. There are no reasons at all. The issue that our application is frivolous comes now. And one wonders because in our application, we are dealing with the powers of the minister. The powers of the minister to grant such an important exercise as an exemption of the Zimbabweans on this application. If this is not an important application, if this is not an application that calls for of public importance, then the standard is really being interfered. Then, lastly, I want to deal with the issue of the paragraph 18 of the judgment, where we submitted that the wrong test was applied. We still say the wrong test was applied. Of course, there is a reference there to the two-stage test, but what our opponents are losing sight of is that we have explained our application, our affidavit states the circumstances or the steps that were done by the truck drivers before they come to court. All those interactions, they've been summarized in detail in our heads of arguments with reference to the affidavit. I think in my mind what the other side are looking for is an affidavit with a heading called Application for Condonation of the Late Filing. But that we submit with respect is not necessary. The court, it has rightly stated in footnote 14 of the judgment, can glean from the affidavit whether there are reasons. And in this regard, we would like to refer the court to the well-known case of Buffalo City, paragraph 51 and paragraph 52. If I may just read paragraph 51, which simply states, the second difference between PAJA and legality review for the purposes of delay is that when assessing the delay under the principle of legality, no explicit condonation application is required. The court can simply consider the delay and then apply a two-step Kumalo test to ascertain whether the delay is undue, and if so, whether it should be overlooked. And as we started this morning, we said, because the door simply closed, the court simply closed the door on us on the 180-day test. The court did not, in our submission, go to the second test of Kumalo. Of course, it is mentioned in footnote 14 of the judgment. We accept it, but the judgment does not, the reading of the judgment does not show that. And we submit that clinging from our application and clinging from our reference to those relevant paragraphs in our hearsay documents, a court would have found the delay is explained and would have exercised its discretion whether or not to overlook the discretion the delay. Of course, that does not apply to the extension of December 2022. Our application was in February 2023, if I'm not mistaken, which cannot be regarded as an unreasonable delay. And based on that, we submit with due respect that this is the case where leave to appeal to the Supreme Court of Appeal should be granted. And those are our submissions. Unless there are questions from the bench, those are our submissions.
All right. Judge Malindi?
No questions. Thank you, my sister.
Judge Mutlo?
I have no questions. Thank you, my sister.
Okay, thank you, Mr. Majapelo. There's no questions.
Thank you, my lady.
Yes, we are going to reserve our judgment on those two applications for leave to appeal, and then we'll hand it down as soon as it is ready. The parties must bear in mind that the court is actually now in recess. So we accommodated the hearing of this application because you had sent through the request during term already. But we'll only hand down the judgment once the new term commences. And we'll advise the parties, and it will be uploaded onto case lines.
As a court.
Right.
As the court pleases.
Thank you. You're excused then.
Thank you.
Thank you.